I can't possibly provide you with legal advice in this forum, so it's not offered as such. Think of it as education or attorney advertising, but not legal advice. And with that out of the way, let's talk about the law. If you are considering federal registration of your trademark, and you really should be, you have probably come across this concept of use in commerce. It's a requirement. You need to have use in commerce of your trademark in order to actually get a federal registration of your trademark with the USPTO. So what does that mean? Most of the time what that means is you're selling your services or goods across state lines. I'm in Washington. If I was selling in Idaho or Florida, I would definitely be in commerce for the purposes of applying for a federal registration of a trademark. But I'm going to take it one step further. Where does this idea of commerce come from? Because it doesn't just mean doing business. That's not what it means. It actually comes from the Commerce Clause in the Constitution. Article 1, Section 8, I think it's the third clause down, is referred to as the Commerce Clause. It is the source of Congress's ability to regulate commerce. And it refers to commerce between the states, between the U.S. And foreign entities, and with native tribes, native peoples. So that's where the term actually comes from. What that then means is that, sure, if you're selling in multiple states, you're in commerce. You are engaging in an activity that can be regulated by Congress. That's the point. So what that means is there's a number of other ways that you can do it. I have a client that they operate in Alaska, and only in Alaska, but they work with native tribes. So they're doing something that can be regulated by Congress. So their efforts are in commerce in that context. I have another client who it's a vineyard, and they only sell in the state where they grow the grapes. That's it. They don't deliver across state lines at all, but it's agriculture. Agriculture impacts interstate commerce. It's therefore something that can be regulated by Congress, and it is therefore in commerce. I have another client it's a restaurant. They don't deliver to the next state over. It's just a restaurant on a road. But because restaurants and hotels cater to people who are traveling interstate, they then impact interstate commerce. They are therefore in commerce for the purposes of this federal regulation and for getting federal trademark protection. So don't think that you just have to sell to a different state in order to be in commerce. That does work, but there are a number of other ways. So reach out to your attorney and find out. You might be eligible for a federal trademark protection right now, even though you're not selling into another state. It's all your intellectual property. You have more of it than you think. We'll be back again soon.